Good morning, everyone. Today we are going to analyze one problem question in easement. Disclaimer: this video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. A common scenario in easement disputes involves an initial agreement where a person A grants access to person B in exchange for something. Subsequently, the person A sells their property to person C, who then denies access to person B. So this denial will trigger a response from person B, who retaliates by blocking access to person C. You can find most of the easement questions in this way. Let's see our case, our problem question. In December 2019, David needed to raise money to help pay for the upkeep of his townhouse. He therefore granted Ben, a local plumber, a 3-year lease of the flat in the basement of his house. The flat had its own entrance downstairs, situated at the rear of the townhouse, and benefited from a small courtyard. On most mornings, after Ben moved into the flat, he was amused to see David using the courtyard belonged to the flat to practice martial arts. He did not mind. Ben also did not object when every few weeks David entered the courtyard to check and clean otherwise inaccessible parts of the townhouse roof guttering. In March 2020, David gave up driving. He sold his van to Ben. David told Ben that he has welcome to continue parking the van in the same space in front of the house, where hey, David had usually parked it. Ben needed to carry his plumbing tools back and forth from the van and the flat. Ben gratefully accepted David's invitation to use the shorter route through the front door of the house and down an internal staircase to reach the flat. In December 2022, David granted Ben a new 3-year lease of the basement flat with identical terms. Last month, when David decided to move into the care home, he sold the freehold of the house to his martial art instructor, Reis. Reis has since told Ben to stop using the front door and the internal staircase in the townhouse and remove his van from the parking space at front of the house so that he can park his own car there. Furious Ben blocked the access to the courtyard so that Rice cannot use it to practice martial arts or to clear the roof guttering. We have to advise Ben on this situation. We know the requirement of valid easement. It should be the dominant and servient tenant, accommodation of the land, diversity of the ownership, and subject matter of the grant. Let's say the dominant and servient tenant. The leased basement flat was the dominant tenant, and the townhouse was a servient tenant. Accommodation of the land, the easement over the courtyard, the access through the townhouse, and the parking space all accommodate the use and the enjoyment of the dominant tenant, the leased basement flat. A diversity of ownership and occupation, as mentioned earlier, a landlord tenant relationship between the David and Ben satisfy the diversity of the ownership or the occupation requirement. A subject matter of the grant, the easements were created through the express grant of the lease and the implied grant of the access and the parking rights. What are the potential issues and implications? When David sold the freehold of the townhouse to Rice, the existing easement should have been transferred to the new owner, Rice, as they were established and attached to the land. Rice's actions in prohibiting the Ben from using the front door and internal staircase and the courtyard, as well as removing the Ben's van from the parking space, may constitute a violation of the established easement rights. Ben may have grounds to seek legal recourse against Rice to enforce the existing easement rights as they were created and attached to the land before the change of ownership. The court may need to consider the scope and the extent of the establishment easement, as well as any potential limitations or modifications that may have been made over the time, in order to determine the appropriate remedy for Ben. Let's analyze this easement problem based on different aspects of the easement. Easement over the courtyard. The facts indicate that David was using the courtyard belonging to the basement flat to practice martial arts, and he also accessed the courtyard to check and clean the roof guttering. This suggests the potential existence of an easement for the David, and now rise to use the courtyard. The case of Ellenborough Park established the requirement for an easement, including that the right must be capable of existing as an easement and must be accessible as of right and must not require any action on the part of the servant owner. Easement over the courtyard. Here, the use of the courtyard by David seems to meet this requirement as it is a positive easement. That means allowing the dominant owner to do something on the servant land. And does not require any action from the servant owner, the basement flat tenant. However, the case of Phipps versus Pierce suggests that the court may be reluctant to expand the category of the negative easement to prevent the servant owner, Ben, from blocking access to the courtyard. Therefore, the easement over the courtyard may be upheld, but the scope of easement and the ability to prevent the servant owner from interfering with it may be limited. Let's move on to the easement for parking and access. The facts indicate that David allowed Ben to continue parking his van in the same space in front of the house and to use a shorter route through the front door and internal staircase to access the basement flat. This suggests that the potential existence of the easement for the parking and the access. The case of Moncrief versus Jamison established that an easement cannot impose a positive obligation on the servant owner, such as maintaining a swimming pool. Similarly, the passage indicates that the servant owner, David and now Rice, was not under any obligation to maintain the parking space or the internal staircase. Therefore, the easement for the parking and the access are more likely to be upheld as they are the positive easement that do not require any action from the servant owner. What is the implied easement under Section 62 of the Law of Property Act 1925? The passage mentioned that David granted Ben a new 3-year lease in December 2022, which may have included the express or implied easements. Additionally, the Law of Property Act 1925 and the Land Registration Act 2002 may provide for statutory easements or the covenants that could be relevant in this case. For example, Section 62 of the Law of the Property Act 1925 may imply certain easements such as right of way in the absence of any express provisions. The Law Commission report on making the land work, the easement, covenants, and the profits appurtenant may also provide guidance on the interpretation and the application of these legal principles. The first situation under the Section 62 LPA 1925 applies here, where the dominant tenement, the basement flat, and the servant tenement, the townhouse, have a common owner, David, who grants a lease of the basement flat to Ben. David granted a lease, a conveyance of the basement flat to Ben. There was a diversity of occupation as Ben occupied the basement flat and David occupied the townhouse. The rights relating to the courtyard and the internal staircase access were related to the land and were not merely the personal privileges. There were no contrary intention expressed as David did not indicate the rights were only temporary. Therefore, the permissions granted by David to Ben to use the courtyard and the internal staircase access were likely converted into implied easement under the Section 62 LPA 1925 when the lease were granted. So, what is the David's rights over the courtyard and the roof guttering? David used the courtyard belonging to the basement flat to practice martial arts and also entered the courtyard to check and clean the townhouse roof guttering. This suggests that David had some form of rights or easement over the courtyard, likely an easement of use. Under the common law doctrine of easement, it is possible for a landowner, David, to have an easement over the part of their own land, the courtyard, that is leased to another party, Ben. This type of easement is known as easement in grass and can be created by the express grant or implications. Given that David's use of the courtyard was known to Ben, and Ben did not object. It is likely that David had an implied easement of use over the courtyard. This easement would have attached to the townhouse property and would have passed to the new owner, Rice, when the David sold the freehold. Similarly, the David rights to access the roof guttering through the courtyard may also have been an implied easement as it was necessary for the maintenance of the townhouse. Let's move on to the courtyard and the roof guttering access. David's use of the courtyard to practice martial arts and access the roof gutters could potentially be considered as a continuous and apparent quasi easement under the principle established in Wilden versus Burroughs and P&S Platt Limited versus Crouch. As a common owner occupier, David's use of the courtyard and the access to the roof gutters was continuous and apparent, and these rights were enjoyed with the townhouse. Therefore, under the Section 62 of the Law of the Property Act 1925, these rights may have been impliedly granted to Ben when David leased the basement flat to him. Consequently, Ben may have a valid easement to continue using the courtyard and accessing the roof gutters even after the sale of the townhouse to Rice. So, what is a Ben's right over the front door, internal staircase, and the parking space? Ben was granted the right to use the front door and the internal staircase to access the basement flat, and that David allowed Ben to continue using the parking space in front of the house where David has usually parked his van. These rights may have been granted to Ben either as a part of the original lease of the basement flat or as a separate license or the easement. If they were the part of the lease, then they would have been transferred to Ben as part of the leasehold interest. If they were granted as a separate rights, then they may have been either legal easement or equitable easement, depending on how they were created and whether they were registered. Under the Land Registration Act 2002, we know that legal easements that are either expressly created or implied can override a subsequent transfer of the servient the townhouse, and provided they are either known to or reasonably discoverable by the purchaser rights or have been used within the year before the purchase. The equitable easement may also be able to override a subsequent transfer, but the law in this area is less certain and may depend on the nature and extent of the use of the servient easement. Given the limited information provided, it is difficult to definitely conclude whether Ben's right over the front door, the internal staircase, and the parking space would have been effectively transferred to Rice. This would depend on the specific nature and documentation of those rights. Let's move to the courtyard and access through the front door and internal staircase. David's use of the courtyard to practice martial arts and maintain the roof guttering likely constitute an easement by prescriptions. Under the principle in the Re-Ellenberg Park, this use was continuous, open, and without force or secrecy for the relevant period and was enjoyed as a matter of right rather than by license or permission. This creates an easement over the courtyard for these specific purposes. Similarly, David's invitation for Ben to use the front door and internal staircase to access the basement flat likely created an easement by grant. As per the Bachelor versus Marlowe and Markham versus Jamison, this does not confer an exclusive possession and it is a valid easement. What is the easement of necessity? The permission granted by David to Ben to use the internal staircase to access the basement flat may also be considered an easement of necessity. In Bachelor versus Mallow in 1948, the court held that an easement of necessity may be implied that the land granted would be of little or no value without the easement. Here, the basement flat would be of little value to Ben without the ability to access it through the internal staircase, as it had its own separate entrance at the rear of the townhouse. What is easement by prescription? It's nothing but a continuous use. The use of the courtyard by the David for martial art practice and maintenance of the roof gutters may have given rise to an easement by prescription. In Moncrief vs. Jamish in 2007, the court held that continuous use of the land for a 20-year period can give rise to an easement by prescription. If David's use of the courtyard was continuous and uninterrupted for the required 20-year period, this may have created an easement by prescription in his favor. Estoppel. A doctrine of estoppel may also be relevant as David expressly granted Ben a permission to use the internal staircase and the parking space. And Ben relied on these permissions. In Moorcock in 1899 case, the court held that where a person has acted to their determined in reliance on a representation, the law will prevent the person making the representation from going back on it. Here, Ben may have a claim of estoppel against Rice, a new owner, as he relied on the David express permissions. In parking space, the David intention for the Ben to continue using the parking space in front of the house likely created an easement by grant. However, the case like Batchelor versus Mallow suggests the court will scrutinize whether this amount to exclusive possession. The fact suggests this was a more limited in scope, just parking the van, so it is likely an valid easement. Blocking the courtyard. Rice's attempt to block Ben's access to the courtyard would likely be considered an interference with the established easements. Under the principles in cases like Re Ellenborough Park and Regency Villas versus Diamond Resort, Rice cannot unilaterally revoke or interfere with these easements that have been created and enjoyed. So, establishing the Ben's easement, Ben will want to establish that he has an easement to use the way through the house. This can be done by applying the guidance in Real in Borough Park and Regency Villa versus Diamond Resort, arguing for an easement created by implied grant or the reservation. Ben can also establish an easement to park the van in the space at the front of the house based on the guidance in Batchelor versus Mallow and Moncrief versus Jamish, preventing Rice from using the courtyard. This will depend on whether the David had valid easements to practice martial arts and maintain the roof guttering. The principle in Ward versus Kirkland suggests that could be a valid easement. The transaction into which the easement might be implied is a grant of 3-year lease of the basement flat in 2019 and 2022. A distinction between the reservations and the grant is important, as David would have been reserving the easement for himself, while granting Ben the easement to use the way through the house and park the van. The available method of implied creations or necessity, which is mentioned in Hill versus Tupper, and the common intention in Phibbs versus Pierce, and Section 62 of LPA 1925, where it is stated in Wheeldon versus Burroughs. A priority under the LRA 2002, if David's easement were validly created, they would take the priority over the rights title as a disponee of registration title under Schedule 3, Paragraph 3 of the LRA 2002, according to the guidance in Nicholson versus Barkala and Stafford versus Lee case. So, easement by express grant in December 2019, David granted Ben a 3-year lease of the basement flat, which had its own entrance on the small courtyard. In December 2022, David granted Ben a new 3-year lease of the same basement with identical terms. These express grants of a leasehold interest in the basement flat likely create an easement for the Ben to use the courtyard and the route through the front door and internal staircase to access the flat. Easement by implication. When David sold his van to Ben in March 2020 and allowed Ben to continue parking the van in the same space in front of the house, this may have created an implied easement of the right of way for the Ben to access the flat through the front door and internal staircase. The case of Bachelor versus Mallow and the Mancliffe versus Jamison suggests that an easement may be implied where the landowner conduct indicates an intention to create a permanent right of way. Easement of necessity. The basement flat had its own separate entrance as the rear of the townhouse, but Ben was also granted the right to use the front door and the internal staircase to access the flat. This suggests an easement of necessity, as the rear entrance alone may not have been a sufficient means of access to the flat. The case of Hill versus Tupper supports the recognition of easement of the necessity. What is easement by prescription? The fact mentioned that David used a courtyard belonging to the flat to practice the martial arts and to check and clean the roof guttering. The long standing, uninterrupted use of the courtyard by David may have created an easement by prescription in favor of townhouse, which would now be enforceable against the new owner rise. The cases of Moody versus Tegels, Phipps versus Pierce, and Nicholson versus Barcrow provide the guidance on the requirements for establishing an easement by prescription. What are the relevant legislations and the law commissions and recommendations? Section 62 of Law of Property Act 1925 and the Schedule 3, Paragraph 3 of the Land Registration Act 2002 are relevant to the creation and registration of easements. The Law Commission's report, Making the Land Work, Easements, Covenants, and Profit Appender, a Law Commission number 327 of 2011, provides valuable insights and recommendations on the law of the easements. Express creation. The initial 3 year lease granted by David to Ben in 2019 for the basement flat likely created an express equitable easement. This is because a lease agreement satisfied the requirements of the section 53(1)(a of Law of Property Act 1925, even though it did not meet the legal formalities for a legal easement. So the subsequent 3 year lease granted by David to Ben in December 2022 also likely created an express equitable easement on the same basis. Express reservation. When David sold the freehold of the house to Rice, he did not expressly reserve any easement in favor of the basement flat. This means that any rights Ben had to use a courtyard, access the flat through the house, or the park in front of the house were not expressly reserved. Implied creation. The easements of necessity. When the Ben does not appear to be landlocked or lacking any realistic means of access to the basement flat. Therefore, an easement of necessary is unlikely to be implied. What is a common intention? It is possible that an easement could be implied based on the common intention of the parties, David and Ben, where the initial lease was granted in 2019. The facts suggested that David allowed Ben to use the courtyard and access a flat through the house and park in the front, which seems to have been the common intention at that time. However, the court have strictly limited the scope of implied easements based on the common intention, particularly when it comes to implied reservations. Given that David did not expressly reserve these rights when he sold the freehold to Rice, it may be difficult to imply such easement retrospectively. Extinguishment of easements. When David sold the freehold to Rice in 2023, the implied easements may not have been extinguished as per the principle in Wall versus Collins. However, Rice has now told Ben to stop using the front door staircase and remove his van from the parking space. Ben has a strong argument for the existence of several easements over the townhouse and its associated areas. An easement to use a courtyard for access to the roof guttering and for David's martial arts practice. An easement to use a front door and the internal staircase to access the basement flat. An easement to park his van in the space in front of the house. So he has three strong arguments for the existence of the easement. Let's conclude. Ben likely has an valid easement over the courtyard and for specific purposes, as well as the right to use the front door or the internal staircase and the parking space. Rice cannot simply revoke these without Ben's consent, as they constitute established easements that run with the land. Ben should be able to continue using these rights despite Rice's attempt to block the access. Ben may have the following claims against Rice. The implied easements under Section 62 of LPA 1925 for the use of the courtyard and the internal staircase access. The second one, the easement of necessity for the internal staircase access. Third one, the easement by prescription for the use of the courtyard. Finally, the estoppel claim based on the express permissions granted by David. So the Rice's actions in denying Ben's use of the front door, internal staircase, and the parking space may be in violation of Ben's established rights. Rice attempt to prevent Ben from using these rights may be in violation of the established easements. Ben should be able to continue using the courtyard, the front door, and the staircase, and the parking space. And these rights appears to be valid easement that accommodate the dominant tenement, nothing but the basement flat. So the Ben likely has an express equitable easement over the courtyard, access through the house, and the use of the parking space based on the initial and renewed lease agreement with David. However, he may face difficulties asserting these rights against the new owner, Rice, as they were not expressly reserved when the freehold was sold. The scope of any implied easement based on common intention is also likely to be limited. I hope the analysis of the easement problem question is very useful for you. Thank you.